Welcome to Blackstone Solicitors. Today, we're tackling a complex and increasingly discussed topic, transgender eligibility in sport, and the current legal standing of national governing bodies across the UK. In recent years, the question of who can compete in which category has moved from a niche debate to, well, front-page news. For governing bodies, the challenge is balancing inclusion, fairness, and legal compliance, all while under intense public and political scrutiny. So, where do things stand? Across the UK, most national governing bodies, often referred to as NGBs, are independent organisations responsible for setting the rules of their sport. That includes eligibility criteria. However, they do not operate in a vacuum. Their policies must align with the Equality Act 2010, which protects individuals from discrimination on the basis of protected characteristics, including gender reassignment. That said, the law does allow for certain exceptions. In sport, if physical strength, stamina, or physique are decisive factors, organisations can lawfully restrict participation in gender categories to ensure fair competition or safety. This is where many NGBs have focused their legal justification. As a result, we are now seeing a fragmented landscape. Some sports have adopted an open category alongside a protected female category. Others have introduced stricter eligibility rules based on biological sex. A few still allow participation based on gender identity, often with conditions such as hormone levels. Each approach reflects a different interpretation of both fairness and legal risk. From a legal standpoint, the key issue is justification. Any restriction must be proportionate and based on evidence. Governing bodies must be able to demonstrate that their policies are necessary to achieve a legitimate aim, such as safety or competitive fairness. Without that evidence, they really do risk legal challenge. We are also seeing increased scrutiny from regulators and the courts. Policies are no longer just internal matters. They can be subject to judicial review, discrimination claims, and reputational consequences. For athletes, this creates uncertainty. Eligibility can vary not just between sports, but even within different levels of the same sport. For organisations, it creates a compliance challenge that is constantly evolving. So, what should NGBs be doing now? They should be regularly reviewing their policies, ensuring they are based on up-to-date scientific and legal evidence, and documenting their decision-making carefully. Transparency is key. So is consistency. At Blackstone Solicitors, we can advise organisations navigating these exact issues. This is an area where law, science, and society intersect, and it is changing rapidly. If you would like guidance on how these developments may affect your organisation, please get in touch. Thank you for watching, and we will see you next time.